effectively, it is now a scientifically accepted fact that the performance of the human brain can be represented as if it were operating in two systems, which can sometimes operate concurrently. System 1 and System 2. System 1 is the more instinctive, reactive part, which basically works on autopilot. And System 2 is the more deliberate, analytical part that consumes a lot of energy and is atypical. The judicial system. Thomas, can you turn your microphone on mute?
Okay. I will. Yeah, I'm just going to have a look where I can do that.
Okay, I'll do it for you. It's fine.
Probably.
Yeah. Okay, so the judicial system functions on the premise that people are always operating, or the judges and jurors are always operating on System 2, whereas whether or not a person can operate on System 2 firstly is down to their genetic predisposition. When I say whether or not they can operate on System 2, I mean for a considerable time. Okay, so I was saying that the extent to which people can operate in System 2 depends on their genetic predisposition and also on the extent of training that they've received, generally in their formative years. There's considerable scientific research on the subject, and I am referencing both contemporary books about judges and jurors, which are critical of the presumptions upon which the judicial system operates. And I'm also referencing the scientific studies about core phenomena, which we say are implicated in the malfunctioning of the system. So that's one thing. The second thing is that there's a theory called the social contract theory, which basically stipulates that the way the brain is configured is such that there are two nodes where logic is processed. One node processes logic that is purely abstract, so mathematical logic, let's say, and another node processes logic that has to do with social justice and equity in human interactions. And basically, the two can concurrently operate on the same subject at the same time, or in respect of the same subject at the same time. But it is highly unlikely because what generally happens is the part of the brain that processes logic concerned with social equity and justice, which is the more reactive part, will come to a decision immediately before the other part will have time to process things the way it requires it. It requires to be processed in order for it to come to the conclusion. This is different from the System 1 and System 2 thing that I was talking about, which was about whether a person reacts instinctively or whether they are calculating things scientifically before making decisions. Now, the other part about the difference in the way logic is processed is that it leads to further reactions from people based on the inferences that they've drawn, especially when it comes to the social justice and equity issues. So I'll give you an example. Let's say you have an experiment where you have people, judges, assessing whether or not a group of people is complying with a set of rules which are supposed to be abstract completely, but let's say one out of the three rules that they're enforcing is also something that accords with people's sense of right and wrong. So let's say the people that are judging are supposed to observe the interactions of 10 people, and the first rule is that every time they observe someone making eye contact with another person, both people who've made eye contact need to immediately look the other way, as in 180 degrees from the position that they were in when their eyes locked. That's the first rule. The second rule is that if someone punches someone in the face, they must apologize for it. And the third rule is that if someone uses the word, let's say, abstract in conversation, then they have to pause for 30 seconds before using this next word. Now, it wouldn't surprise anybody that once people are told about these rules, it's much easier for them to enforce the second rule versus the other two rules. It's much easier for them to remember the second rule as well, which is that if you punch someone, you have to apologize to them. This is not because of any other reason, but that, over the millennia that we've spent living in our current, as our current species, we have been conditioned to accept and comply with some basic rules of etiquette, and that feeling is very strongly embedded in people genetically. So everybody finds it offensive when people just punch someone because they can get away with it, and those are the rules that people will immediately enforce. And in an experiment where punching someone in the face was okay, people will still struggle to accept that, because the part of the brain that processes the abstract logic is different from the part that processes the logic in relation to social interactions. So the problem this poses for the judicial determinations is that the law is supposed to be abstract in great part. Laws are not driven or underpinned by moral considerations necessarily. I mean, whether or not, what I'm trying to emphasize here is that the enforcement of the law is not contingent on whether or not the law was morally consistent with what people's, core beliefs are. So you will have some laws which are purely formal and statutory, which do not really operate in a context where there are victims or people who are cheating and getting away with it. Jaywalking would be an example, for instance. It's more about a policy that the government is trying to enforce. But the second situation is where you have people who have been wrongly accused of certain things, and it's only through an exhaustive examination of all the evidence or all the whether it's direct or circumstantial evidence, that someone can make out that the person was innocent, or that the system had fulfilled its burden of meeting the relevant evidentiary standard. So in order for people to do that, they have to use a different part of their brain. But the problem is that the part of their brain that processes social justice related matters overrides that, and it prevents them from seeing it in an abstract sense, which the law sort of presumes that they will do. The other problem with people in terms of fundamental incompatibility with fulfilling a judicial role consistently is that as they are deprived of energy, their tendency to go back to instinctive functioning increases highly. So there was a very famous study conducted in 2020 or thereabouts, which followed several dozen judges at the highest criminal appellate court in Tel Aviv. This was coordinated. The study was coordinated through the faculties at Harvard and whatever the most prestigious university in Tel Aviv is. And what the researchers did was they examined these judges as they considered parole applications for people that were convicted of some of the most serious crimes. And they found that there was a consistent correlation between at what time in the day an application for parole was heard and whether or not it was successful. So applications that were heard first thing in the morning had a much higher rate of success compared with applications that were heard just before lunch. And applications that were heard just after lunch had a much higher success rate than applications that were heard just before the end of the day. And the only criterion that they could identify to explain the observations was that the blood sugar level was influencing whether or not the judge's brain would allocate enough resources to basically critically examine the process that was undertaken. So this is again an important context. Now, there's a few other things that affect judicial decision making critically, but I'm not going to go into that in much detail. I told you all of this because these things formed an important context in relation to how we dealt with Gordon and the LSP in terms of how we set up a strategy to identify what they had done.